Everybody for joining us. My name is Maury Litwack. I am the Managing Director of Public Affairs for the Orthodox Union. I am the founder of the Teach Coalition for those who are involved in Teach. But today I am moderating a panel of brilliant legal minds and people who've been involved in this work for a very long time in terms of briefs on these decisions, in terms of their activity on the court. And we're very, very lucky to have them both here today because it's been extremely busy and they're very, very popular people. So we're really excited to have with us Professor Avi Helfand and our very own Nathan Diament. I'll just give you each of their bios very briefly, which is Professor Helfand is currently Professor of Law and Vice Dean for Faculty and Research at Pepperdine. And he's also been a visiting professor at Yale Law School. He received his JD from Yale Law School and a PhD in political science from Yale. And Nathan received is an honors graduate of Yeshiva University and Harvard. He has been extraordinarily active for decades on issues including religious liberty issues including school choice. He's served on the President's Faith Advisory Council and also has been, I don't even know how many briefs he's been cited on and worked on over the last multiple decades within the Supreme Court on some of the leading issues and things that we're going to be talking about today. So both of these individuals are the go-to source within the Jewish community when it comes to these types of issues, so that when a decision like this came out yesterday and everyone was extremely excited about it, my first calls obviously are to Professor Helfand and to Nathan Diament. And so I want to start, if we can, with Professor Helfand, who's going to give us a little. I don't have a law degree, and I assume a lot of people on the call do not. He's going to give us a guide to this for those of us who are not lawyers, or those of us like myself who did not do well in the LSATs. So, Professor Helfand, what do you got for us on this? And what can you give us an insight into this decision? What was this about?
So this decision is about a really interesting tuition assistance program in the state of Maine. Maine has lots of rural areas, and so over half the school districts don't have a public high school. So you wonder where the kid's going to go to school. And so what Maine did was they created a program where if you lived in a school district and it didn't have a public high school, you could go to a private high school, and the state of Maine would fund the standard amount of tuition. Starting in 1981, because of some of the older separation of church and state cases that were not so hospitable to funding, starting in 1981, the state of Maine said, yes, we will provide tuition assistance to the private high school in those school districts, but not if you're sectarian, not if you're a religious school. And over the past any number of years, parents have tried to fight this exception. And in yesterday's decision, a group of parents were finally successful. And here's what their claims look like. Pretty straightforward. The First Amendment prohibits religious discrimination. You provide funding for all private high schools if you live in one of these school districts. You should also provide funding for a religious private high school. You shouldn't be able to discriminate on the basis of religion. Now, Maine, who had actually won the case in the federal court below, had the following argument. They said, this isn't religious discrimination. We're not discriminating against religious institutions. All we're saying is we won't fund religious curricula. So that's why we won't provide funding to religious schools, because they're teaching religion. And this is what's often called the status use distinction. We're not saying that it's a problem to be a religious school. We're saying we just won't fund religion. The Supreme Court yesterday, and this is kind of the big ticket line from the opinion, the Supreme Court basically said discrimination is discrimination. I don't care if you call it status. I don't care if you call it use. I don't care if you tell me it's because it's a religious school or religious curricula. It doesn't matter. If you have a funding program that is secular in nature, it's trying to provide education to kids, and it's neutral. You're going to apply it equally to everybody. What that means is you have to apply it to religion and non-religion alike. And so that means religious schools can participate in a program, this tuition assistance program, and get funding if parents and children select their schools.
Thank you very much. Now, Nathan, you've been you founded the OU's Washington office. You're the executive director of the OU Advocacy Center. You've been doing this for a number of years. And I know you're also a big fan of baseball. And I was going to ask you, as someone who can explain this to us a little bit in the context of it, this is not the first World Series for you. This is not your first pennant. So where does this fit in terms of all the other decisions that you've seen? Because we've heard a lot about this over the last few years. So where does this fit?
Thanks, Maury. I'm going to switch from a baseball metaphor to a track and field metaphor, which is, the advocacy that the Orthodox community in particular has been a leader on for decades. This is a marathon. It's not a sprint. And I guess I would say, if a marathon is 26.2 miles or whatever it is, we're somewhere around mile 20 out of 26. I mean, we really, this has been decades in the making. And I just want to provide a little bit of context. You go back into the 1950s and 60s, the American Jewish Advocacy, and my good friend Professor Helfand has actually written about this in some interesting ways. But back in those earlier decades of the 20th century, American Jewry was represented in these kinds of issues by what you might call the large secular advocacy groups, the Anti-Defamation League, the American Jewish Congress. And they were all advocating for strict separation of church and state. No government dollars should ever go to religious institutions for any reason whatsoever. And they advocated that to the Supreme Court. So in the 60s and 70s, when you had a very liberal Supreme Court, they were striking down school aid programs to a certain degree at the behest of these liberal Jewish advocates. So in 1973, they struck down a program in New York that provided money to Catholic and other parochial schools to repair their buildings if their buildings had physical, repair needs. The Supreme Court struck down a Pennsylvania program that provided tuition assistance to low-income families to attend religious schools. In that era, the Orthodox Jewish community realized that kind of approach, this strict separation approach, is not consistent with our community's interests and not consistent with our community's values. And you had predecessors, founders of this effort, people like Nathan Lewin, people like Marvin Schick, who founded Kolpa, people like Moshe Sher at Agudath Israel, who really said, we're going to go in a different direction in the Orthodox Jewish advocacy world. We're breaking away from the establishment of the AJ Congress and ADL, et cetera, and we're going to advocate. We certainly don't want Christian dominance in America, but we want fair treatment. And we don't think there's anything wrong with religious institutions being supported as long as it's done in a fair way. And then over the subsequent decades, really accelerating in the 90s into the 2000s, where you had the court shifting away from this strict separation of church and state model. And you had, for example, 2000, I would say, was a watershed moment when the Supreme Court said school voucher programs are constitutional. They didn't require states to enact school voucher programs, right? But school voucher programs could not be stopped as being unconstitutional. And now we're here 20 plus years later, and this is the third opinion in the last 5 years by this Supreme Court, really solidifying this notion that, as Avi Helfand said, discrimination is discrimination, and you can't use separation of church and state as an excuse or as a rationale to discriminate against religious institutions. Once the government decides, the federal government, the state government, once they decide in the education context, we're going to do something to support non-public schools or families that send their kids to non-public schools, they may not say, oh, except if it's religion. And by the way, this isn't only about education. Although this case was about education, I think it's very, very clear it goes beyond education. So if the government decides, for example, as it did, in the COVID relief programs, we're going to provide financial aid to employers, including nonprofit employers, to stay afloat and to keep their people on their payrolls during this terrible pandemic, and we're going to help pay salaries. It wasn't litigated, but we now know, right? It would have been unconstitutional for Congress to say, we're going to provide those funds to nonprofit businesses, but not to religious ones. It's really dramatic. And you know, if the finish line for the purposes of this audience and this discussion is the government writing subsidies for Jewish day school tuition, we're not at that finish line yet. That's not what this case says. But we're a lot of the way there because of yesterday's court decision.
So just in that vein, can you each give an example? Nathan touched upon it from a COVID perspective, but can you each give an example practically for the audience in terms of what this means when legislation is being created in their home city, home state, home area? Can you each give us an example? Professor Helfand, can you start in terms of what's a practical example of now what happens when legislators are looking to create legislation?
Let me break it into two categories: existing legislation and future legislation. Existing legislation, what ought to happen now is, given what the Supreme Court said yesterday, advocates ought to be identifying government programs, federal, state, and local, where there are unconstitutional exclusions of religion. So I would say UPK, the program in New York, where you can't provide religious instruction during the hours where you're receiving funding for kindergarten funding from the government. I think somebody will probably pretty soon, if I had to guess, file a lawsuit saying you can't exclude religious instruction if you're providing funding for universal kindergarten. In California, non-public schools, which is a category of schools that can provide schooling for people with IEPs. There's an exclusion in California that says school districts will provide tuition dollars for those students, but not if the school is sectarian, is religious. I think somebody's probably got to file a lawsuit in order to say that's now unconstitutional. New Jersey, when they have historic preservation grants and they have a state constitutional provision that says no aid should go to religious institutions. And just a couple of years ago, a church was lost out on funding because it was a historic church, but some of the funding was going to upkeep and renovate the chapel. That exclusion of the church or any other house of worship, also unconstitutional. All of these are existing programs that have these exclusions. And if we're going to be consistent and apply the Supreme Court's ruling from yesterday across the board, all of those exclusions should go down. In terms of future funding programs, you know, one of the things that it does is it makes, you know, more natural alliances. Religious communities, when they see that there's an initiative for a funding program, for some sort of secular funding program, for the environment, for historic preservation grants, for education, whatever it may be, what they know is if they work with other communities and get a funding program, again, geared towards secular public policies, there is no government official that is allowed under the First Amendment to exclude religion and religious institutions. And that means advocacy arms should get to work building more partnerships and finding more public policies that the government ought to be funding. Maybe I'll say one last really quick thing. We are seeing a change across the United States post-COVID in terms of school choice programs. I think there is a widespread public opinion that the infrastructure of America's public education was not sufficiently up to the challenge during COVID. And as a result, private schools may need to help to make sure every child gets a good education. If that trend continues and these programs get rolled out state after state, city after city, it means in each of those circumstances, religious schools can both help those programs, advocate for those programs, and also know that they'll be included in government funding on the back end.
I asked for one example and Professor Helfand gave me like 6. It reminds me of when we're fasting and everything, many examples. Reminds me when we're fasting and everyone gets so excited thinking about all the food they're going to eat afterwards. And so it seems like you've been thinking a lot about all these opportunities for our community, which is great. So I'm very excited. Most of my analogies are food related. So Nathan, are you as hungry as Professor Helfand? When you've been looking at this for as long as you've been looking at it also, are you as hungry for that? I mean, we saw just immediately a couple of you pop up and I'm getting texts saying, wow, you know, the UPK is massive. There's other opportunities that are massive. We have situations where they say, yes, busing over here, no busing for you. Like we have these situations all over the country. The community feels really almost like oppressed by some of this and just feels like there aren't those opportunities. So how hungry are you on these things? How excited are you from that perspective of having worked on this for so long?
Look, again, this is opening a door to all kinds of things. I'll mention one other education. By the way, I think you touched on something very important, which is bus transportation. It's ironic that in the first case, which sort of started the Supreme Court's jurisprudence in this area of the law, was in the 1940s, and it involved school bus transportation. And then back then, the Supreme Court said it's constitutional to provide school bus transportation to kids going to religious schools. But we still don't have it, everywhere. But in any area of the country where the local government is providing bus transportation for kids to get to school, if they're providing it to non-public school kids, they have to provide it to the religious as well. The other thing, though, that I want to say that's important with regard to existing programs is, theoretically, there are a lot of programs out there that could have been challenged, that we might have had to litigate, whether it's, frankly, the federal nonprofit security grant program that we helped create 20 years ago. I mean, thankfully, the strict liberal church state separationists never had the chutzpah to bring a lawsuit, saying, no, we don't want this synagogue or this day school to be protected against attacks because we don't want them to get government money. We never had to litigate it. But now we know, because it's framed as a program for nonprofits across the board, it's 100% constitutional. The groundbreaking program in New York that Teach Coalition spearheaded, in which the New York State funds math and science teachers, that could have been litigated. We gamed out how that would play out. Here, as long as New York State continues to say we want to subsidize these teachers in the non-public schools, nobody can say, well, you can't give it to the religious schools. It's really very important. We have to continue to think creatively. We have a program at the federal level that we're waiting to get implemented, but is now law, in which that we passed last year for the energy department to be giving out grants to nonprofits to help make their buildings more energy efficient and reduce their overhead by, swapping out old HVAC systems for new ones, et cetera, et cetera. That is clearly constitutional for that money going to synagogues and day schools and churches, et cetera. Right now, we're still looking into the details, but we've been working with partners like the Catholic community and others just in the past week and a half here in Washington, with this gun safety legislation package that Congress has been considering. If they were going to be putting creating some new programs, we were talking with senators about how they would serve our schools with those mental health resources, with additional security resources. That the details of that are still being worked out. But there are a lot of arenas, both in the education space and beyond, that are really open for some creative thinking and for advocacy right now.
Thank you. I have two more questions, one for each of you, and then we're going to open it up to Q&A. And I think these are just questions that people practically are asking. Number one is, Professor Helfand, do people, we've been asked this many times, people say, okay, so I see the ruling, I'm really excited about it. Now next year I'm getting vouchers. Now next year I'm getting tax credits from my state. Can you address that? Because that is a common question that people are getting. There's sort of like that breaking news, and then you sort of assume the next step is that. And so I think practically speaking, people are going to say, okay, well, now the floodgates are sort of open. Can I get those types of things? And what is your reaction to that, just practically speaking?
No, we are not getting vouchers tomorrow. That's the easy one. Let me explain a little bit as to why. Let's be clear about what this ruling is. Government, federal, state, local, has the right to fund, for example, just public schools. They don't have to fund private schools. What yesterday's ruling tells us is, if you fund private schools, then fund all private schools, religious and non-religious alike. And do so because you've opened a program that has a secular objective, education, or again, environment, whatever the program is, security. You have a secular program, and just because we think something is religious, so there's a religious use or it's a religious institution, doesn't mean you can exclude those institutions. So what does that mean? In many states and most states, there's no funding of private schools. There's no general voucher program. That's the predicate you need. You need the broad program, and then you get to make sure that religious schools get to be included. And I want to use that as an opportunity. I saw a question pop up in the chat. Are we worried about this somehow, helping promote the Christianity somehow is going to take over the United States. I want to be crystal clear about what this ruling is, because, critics of it, constantly try to make this point. I had a debate this morning with somebody from the Freedom from Religion Foundation here on NPRLA, and this is the take, that somehow this is going to promote Christianity. For these funding programs to be constitutional, their goal has to be secular. When Maine said we want to provide funding for private schools where there's no public school, they weren't trying to promote Christianity. They weren't trying to promote Judaism. They're just trying to make sure every single child got educated. And any institution that can solve that problem, that can satisfy that interest, ought to be included. That's what the Supreme Court's ruling yesterday said. So it's not like we're taking principles of, equality or neutrality and throwing them out the window. That's actually the core of what this is all about. And I would say one last thing on that. That's part of why the Jewish community ought to be so galvanized around this issue. It's because it's not just about the dollars, but it's the idea that our institutions were second class in some ways when it came to these funding programs. And, really what, in many ways, and this is what the OU's briefing was really on, what we submitted as an amicus brief to the Supreme Court. We don't want to be second class. We want to be treated equally. We want to treat neutrally. We want to show that if our institutions can accomplish what the program is meant to do, then Jewish institutions, religious institutions, any institution ought to be able to participate.
Thank you, Nathan. In this last question, then we're gonna open up. We're gonna start going through some of the Q&A again. If you get a chance, put it into the Q&A. I'll try to grab some from the chat also, but the Q&A just makes it a little simpler for us. Nathan, in New York, New Jersey, California, and Maryland, they make up close to 80% of the Jewish day school population in America. They also all have in common that they are not red states, but they are blue states, and they're very blue states. And so tell us about why this decision is an opportunity for those blue states.
I think it's an opportunity in the blue states, as you say, when we can frame the issue as this court opinion requires us to, as serving a broader societal purpose, right? So again, the groundbreaking program in New York, where New York State is funding STEM teachers in non-public schools. How was that presented to the New York State policymakers? Why did they get on board? Because the argument is you want all your high school graduates in New York to have a certain level of ability and accomplishment so they can be contributing members of society, right? And math and science education is really important to that. So we want to make sure that the very large population of students that are coming out of the non-public schools are able to be contributing members to society and have good, high quality math and science education. Also, if you can persuade a liberal governor and legislature in New York, that they're serving that broader purpose, you get the program. In Maryland, where I live, the number, we're going through elections right now in Montgomery County, Maryland, outside of Washington. And, the perennial issue around here is traffic congestion. If you could, they don't provide school bus transportation for most non-public school kids in this area. Forget about whether it's going to help our families, financially or what have you. If I could get however many hundreds of minivans off the roads during rush hour, we're serving a common need of reducing traffic congestion in the area. So I think even what we need to think creatively about is in the blue states, how can we, and this is not a cynical ploy, but how can we both serve broader social goals and also the interests of our community with creative kinds of proposals like the things that the OU and the Teach Coalition has put forward. This opens the door for us to think about them more creatively.
Thank you very much. So we got a lot of questions. I'm going to try to get to as many as we can. One of the common ones we had right off the bat is a lot of people are asking about how does this ruling affect the ability of religious schools to become charter schools? How does it affect charter schools? There's been a long debate in the community for a very long time about whether or not yeshivas can become charter schools. I'll put my own 2 cents in there, which are charter schools or public schools. I'm not sure exactly how I see this ruling sort of impacting that. I don't know which one of you wants to weigh in on that.
I'll start. So I think we've started thinking about this and talking about this. It's complicated. So I'm just going to give some ideas of, what some of the considerations are. As you said, Maury, charter schools are public schools. I think it's clear that under this ruling, right, and that charter school laws and regulations are different in different states and different localities, okay? But I think what is clear under this ruling is if you have a state or a city that has charter schools and they let various kinds of nonprofits that meet certain kinds of criteria sponsor charter schools, I think this ruling stands for the proposition that if a church comes or a synagogue comes and say, we want to create a charter school and they meet all the criteria, right? The state cannot say, oh, we're not giving you a charter school just because you are a religious institution that wants to sponsor this charter school. I think that's pretty clear. But if you're then you get to the question of but at the same time, the state can say, or the city can say, because as you said, Maury, charter schools are public schools, here are our curriculum requirements for what happens in our charter schools. Now, it's true, the whole purpose of charter schools is for them to have more independence and not do the exact same curriculum as the regular public schools are doing. But that does not mean that states or cities that have charter school programs don't get to set some amount of parameters for the charter school curriculum. So, and that would not be anti-religious per se, right? If they say you need to have X number of hours in math and science to be a charter school, that's not anti-religious generally, although there are some in the Orthodox Jewish community that would have difficulty trying to be a charter school that would have a math and science curriculum, et cetera, et cetera. And that's before, by the way, you get to issues about admissions. There are plenty of charter schools all over the country that are all boys or all girls charter schools. But, again, because they're part of the public system or attached to the public system, you can't necessarily discriminate in admissions the way Jewish or other religious schools might generally want to. So there are a lot of issues around figuring out whether or not charter schools can work. This court ruling, as I say, solves, I think, one of the questions, which is, can a religious institution that is otherwise qualified to sponsor a charter school do so? But there are these other kinds of questions that we still need to spend a lot of time thinking about.
Another question I'll give to Avi that was asked, and I'm biased here, which is what's the impact that this has in terms of property taxes and spending equally going to public and private schools, something that is extremely concerning to those of us who live in places like New York and New Jersey. So I got this from a couple different places. Is there any impact on that at all, or just is another talking point?
I fear I can't really think of anything, meaning government is allowed to fund public institutions. There's nothing wrong with that. If government wants to use its tax dollars, whatever level you're talking about, federal, state, or local, in order to fund public education as opposed to private education, that remains not completely legal and constitutional, long history here in the United States. So I don't really see any impact when it comes to those sort of tax dollars or tax questions. I am sorry to disappoint those of you who were hoping to hear something else.
Well, they're now I got to sell my boat, so I bought it in the last day. Another question here for you, Avi, and I'm going to give one to Nathan is, what impact do you think this has on the title funding services? Is it possible the title funding go more directly to schools as opposed to through the school districts, which is something that a lot of our schools have problems with around the country?
Oh, I think Nathan's probably way better positioned to answer this one.
So again, this is another one that we need to think through carefully. I think it doesn't, this court ruling certainly doesn't clearly answer the question. I think it opens the door to an interesting question, which is, in the major federal education programs like Title I and IDEA for special ed, right? Our eligible students in Jewish schools and other non-public schools get served through equitable services, not through direct funding. I it might be the case, and this is very, very tentative, so please, those of you watching, don't take this to the bank yet, so to speak. We really need to think it through. But if we could demonstrate that the very structure of we provide direct funding to these very same eligible kinds of students in the public schools through direct funding, but we use this equitable services mechanism for the non-public and religious school kids, and as a result of that, they're receiving unequal services that are not actually equitable, right? Either in quality or quantity. I think it's an interesting question whether we could build on this and say, look, the federal government has decided that we're providing this menu of special ed services or this menu of educational services to low-income kids, including those in non-public schools, but they're doing it in a very unequal way. I think it's a question that is, again, this case points to that we need to explore more.
We have a question here from our very own former president, Steve Savitsky at the OU. He asked about his school district is at the cutting edge of providing services to local yeshivot. If they take more bold approaches, like providing services directly to our yeshiva students and get sued, will the OU support them in the judicial process? Now, I'm going to say yes, Steve, no matter what. But what's the more practically speaking? There are a lot of places where people are sitting on the school boards. They've got, even in my local community, they've gotten on the school board to fight for the rights of all parents. So what do those sort of opportunities look like now?
Look, the field is much more open. Look, as I said earlier, in 2000, the Supreme Court said school voucher programs are constitutional, right? Which meant that if you had places around the country where you had the political leadership and the political support to create a school voucher program, go and do it, and nothing's going to stop you, so to speak. So too here, if you have a school board that wants to be more proactive and think creatively about how to do things. Now, they can't do, the flip side of this case is they couldn't decide we're only giving these services or we're only giving this funding only to the religious schools and we're leaving out the secular private schools. That might still be unconstitutional, by the way. You have to do non-public schools as a whole. But, an example that comes to mind based on our experience during COVID, right? If a school district or a state or a city decided, we think it's important for all kids in school to have laptop computers and high-speed internet, right? And we're going to provide that to all families with school children, including non-public school families. They can't say, but not the religious school families. So, if that would be valuable for, that's something we could advocate for, if those kinds of resources, or if you have a school district that wants to do that, go right ahead and do that.
This question is for Professor Helfand. This comes from founder of Teach NYS and co-chair Sam Sutton, who I don't know how we didn't get to this. So thanks to Sam Sutton for this. What about states that blame amendment? What's the difference?
No difference. I think I'm going to have to think about a creative way around this, but in the main, those Blaine amendments, to the extent they allow states to exclude religion and religious institutions from government funding programs, are now unconstitutional. You can't do that because, as we said, discrimination is discrimination. And by the way, not by coincidence, most of those Blaine amendments, most of those states enacted those laws in order to engage in various forms of harassment, violence, etc., against American Catholics. It's high time they're all struck down. And you'd have to find some sort of very strange hypothetical where you'd allow the Blaine Amendment to apply, but it wouldn't run afoul of yesterday's ruling.
Which ironically was from the state of Maine, where Senator Blaine came from.
All right. Is potential op-ed between Professor Helfand and Nathan. So there you go. We got something going. This next question comes from the absolute superstar for the Jewish world and the Jewish Education Project, Sarah Seligson, who's done a lot of these fights for the New York State and New York City schools. She asked, do you think this means that the restrictions in CARES and EANS funding, I think this is more for Nathan, i.e. for HVAC, are unconstitutional?
It's a good question. I think the answer, put it this way, I think the answer is a similar answer, which I don't know yet, to what I said about Title I and IDEA, right? What we don't quite know, and I certainly obviously haven't fully thought through, and maybe Professor Helfand and I need to go like have a cup of coffee somewhere for a couple hours and talk about, is can you still, does this court opinion still allow for situations in which, okay, the government is going to provide some resources for the non-public sector, but they're going to do it in a different way than they do for the public sector, right? So the Chief Justice, in his opinion yesterday, very clearly said, right, responding to Justice Breyer in dissent, responding to critics, right, let me be clear, states can still decide we only fund public schools, right? And sorry, all you non-public schools are left out in the cold. They can still decide to do that, even under this ruling. And as Avi said, what this ruling stands for is if the government opens the door to providing services in an area to the non-public sector, they can't exclude the religious ones. Okay. Suppose they say we're doing something in the non-public sector, but we're not doing it to the same extent. We're not doing it to the same quality as we're doing in the public sector, right? That's kind of the question that relates to what this point and others. And it certainly is not settled by this case, that's for sure. How much this case supports, our advocacy in the next case is what we need to think through.
Okay, we're gonna ask two more questions. I've got one, and if anybody else want to ask anything, please let us know. This is for Professor Helfand. I know you spoke about this briefly, but a couple of people asked about it. Really give us a perspective from a shul perspective, from a synagogue perspective. For example, how does this affect historic or landmark religious buildings? I know Nathan touched on it from a FEMA perspective. So if you're involved in your shul leadership, how are you thinking about this?
What you're doing tomorrow is you're calling either the Orthodox Union or some sort of a local attorney to try to figure out what funding programs currently exist in your jurisdiction, and you're applying as soon as you can. Because the mere fact that you have a sanctuary or there are religious activities going on, etc., no longer excludes you from government funding programs. New Jersey was a really, really big culprit in this, excluding churches from historic preservation grants. There was a lawsuit a couple of years ago. Beth Medrash Gavoa received funding for infrastructure, and that got remanded. But real legal challenges for various forms of general government funding programs that New Jersey's no state aid provision in its constitution New Jersey Supreme Court was using to strike down. The fact that you're a shul doesn't matter anymore. If you satisfy some sort of secular government objective, if you're old, you're historic. It doesn't matter if you're doing religious stuff in there. And if there are infrastructure programs for nonprofits and you qualify, you should be applying. Zero question about that.
The last question is for Nathan. Someone just put it into the chat, which asked what kind of long-term impact would such legislation have in the relationship among communities? I'll ask it a little differently, Nathan, which is amongst the faith-based communities, amongst faith and non-faith-based communities. What do we think of this? Is this good? Is it the way many are portraying it as a divisive issue? But you've written about it and said that this is a positive, that this brings communities together. Professor Helfand's talked about that also. What are your thoughts on this? Because there seems to many times be just this reflexive, like, religion is if we're allowed to do stuff, it's going to be bad. It's going to be negative. So what is your sort of take on that and your last word on that for those listening?
Right. Look, I think an example that we had in the op-ed that Maury and I published together goes back to the big COVID packages, which included, as I said earlier, funding to support the salaries, literally the salaries of clergy people at houses of worship. Like the PPP loans, which became grants, right, paid salaries for clergy. I realize it was an extreme emergency situation, but I would still say if we had been having that discussion in Congress 10 years ago, maybe even less than 10 years ago, there would be all kinds of people in Congress saying, you can't do that. We can't pay the salaries of clergy people, even under the most extreme circumstance. Or by the way, when we created the nonprofit security grant program, 15 years ago, you had members of Congress saying, we can't provide security aid. We can't provide security money to keep synagogues and churches safe because there's got to be separation of church and state. Fast forward to now, I haven't had any of those debates. Chuck Schumer and Mitch McConnell proudly brag about the fact that the COVID relief money was available to religious institutions. So yes, the ACLU is still out there, and Americans United for Separation of Church and State is still out there. They are caught in a time warp of 1973, and and frankly, by virtue of what I just mentioned and many other examples, they can't stop stuff from going through Congress or elsewhere, that's counter to their ideology. So I think in general, the mindset among policymakers, certainly in Washington, has shifted. And also, as you said, Maury, this is not an effort, that what I talked about in the marathon, this is not an effort that was done solely or exclusively by Orthodox Jewish Advocacy. Our partners in this were the Catholics, Seventh-day Adventists, Mormons, in more recent years, Sikhs, some Muslim groups, because all these groups, what all these groups have in common, right, is a recognition that for religious freedom to really be robust in the United States, it has to ensure that all people of all religions are treated fairly, and are all equally able to exercise their religion, are all able equally to access support from the government wherever it's appropriate, and you can't disfavor religion generally, or certainly not one religion over the others. So it really is a cause that's been a multi-faith cause over many, many years. And that also provides opportunity, looking at, again, at the advocacy arena, at what comes next, as the OU and as Teach Coalition have done in building coalitions at the state level, at the federal level, with communities of common interest, to achieve these goals. It's a very important and a very meaningful opportunity.
Well, we appreciate both of our panelists being on there. They have extraordinary subject matter expertise. I'm starting with this bill that I also have great subject matter expertise in this. I do appreciate all the people asking me about my tie and why I'm the only participant wearing a tie. So I do appreciate that. That's what I brought to the table here. But I think these two have incredible expertise built on the fact that they've been doing this for some time. I want to close with the following message, which is that echoing what Nathan was saying in terms of it being a marathon requires training. A marathon requires a lot of hard work. A marathon requires a tremendous amount to get this done. I've only ever done a half marathon. But what I can tell you is that if you stop, or you sort of just wait around and hope someone's going to carry you over the finish line, you're not going to get to the end of the race. So if you end this webinar and you're excited about this and you say, wow, UPK, wow, more title services, wow, more busing, wow, a lot of opportunity, and think it's just going to happen, you're making a mistake. There's 260 people on this participating to this point, but we should have had 2,600 people on here or 26,000 people on here. You need to spread the word in the community that there's opportunities here, but you need to support this type of work that we do at Teach, at OUA. You need to support this work by helping to show up, by helping to participate in the work, by supporting the work, by being there for this type of work. Because if you don't do that, literally, we're going to be talking about this 5-6 years ago and say, we had a lot of opportunity and we didn't do anything. So we strongly encourage people, if you're listening to this, this is a massive opportunity to finish the race. And these incredible people have helped us get this far. Maybe we're at mile 11, maybe I'm at 12, but we've got a way to go, but we've got to be out there and active, and there's opportunities for every one of you. So if you want to, and I love that someone said, we vote politicians, take note. If you are involved, if you want to be involved in these efforts, please, please, please reach out to us. I think Dean, it's Nathan, what is it? It's info@ouadvocacy.org. Is that one of the ones?
Yeah, it's information at teachcoalition.org is one of our email websites.
You can do information at teachcoalition.org or information at ouadvocacy.org. You can ping any of us on social media. We are available for here. We will come to your communities. We'll show you how this is done. We will help you. We will work with you. Please spread this everywhere. Thank you to former OUA board member Stephen Orlow for saying that. Please spread the message out there. We're almost done. We got it. We can get this done. but we need your help with that. Thank you all, and we will just be disseminating this webinar going forward. If we didn't get to your questions, please send them to us and we will answer each and every one of them. Thank you all.